is just close to me, who is partner at DW France, who specializes as an extensive knowledge and expertise in the fields of intellectual property, data protection, and new technology, innovative technologies, or économique, blockchain. Then Giovanni Cucciarata, who is a partner at DWF Italy, so from the Italian angle, who specializes in finance matters, including fintech, obviously. Then Nina Lisa Zidler from DWF, partner at DWF Germany, who is as well specializing in finance matters, including fintech, and also advising a couple of institutions in being interested in this innovative fields, such as Blockchain Hub. And then to face and have a kind of counter-argument with all those lawyers facing you, Mr. Vidal Shriki, who is a technical expert who has developed a high interest in Bitcoin and Ethereum, launched the first French-speaking video series about Bitcoin and blockchain, and is also the inventor of the first online peer-to-peer booking protocol through and to that effect, and to operate that solution, has recently launched a company, BTU Protocol, and raised tokens. So, as you will explain further. So maybe we can start with Italy, Giovanni.
Bonjour tout le monde. Thank you very much for having invited me. So I've been asked to bring here my experience regarding the Italian regulatory framework on token sales, initial coin offerings. As you probably know, Italy doesn't have a specific regulation regarding these matters, and like most of the other countries in the European Union, in the world, there are countries in Europe that had regulated these particular ways of raising capitals through distributed ledger technologies, so blockchain. For instance, Malta, which, as you probably know, has approved 3 bills of law regarding, so a whole package of regulation regarding these aspects. I know that France is also implementing, approving, as Sylvie will tell us later, a regulation. In Italy, we don't have a specific regulation. I think also in Germany, at the moment, we don't have it. My opinion is that we should have it on a European Union level, but Nina Luisa, who is a big expert in this and is also involved in this process, will tell us what is the state of the art on a European Union level in this respect. Coming back to Italy, so the fact that we don't have a specific regulation doesn't mean that this is an unregulated field, because simply to the token sales, to the ICOs, the Italian authority applies the normal existing capital market regulation, which in Italy is the Testo Unico della Finanza. This is very, actually 2-3 weeks ago, we had 3 resolutions of Consob, which is our authority in Italy, that suspended, in particular, 2 ICOs, which were launched by Italian teams through companies which were foreign companies. In one case, a UK company. In the other case, I think it was in Belize, which is in Central America. What Consob stated in these decisions, these resolutions, was that in that particular cases, the ICOs were public offerings of securities under Italian law. So public offering of prodotti finanziari. These are precautionary measures because in fact the authority just suspended for the moment the ICOs, and we will see how it will continue this, because I think that now then we can have a ban or an appeal from the the issuers. We will see how it will proceed. So they are the first decisions we are having in this field. So very interesting. One of the most interesting things of these decisions is that CONSOB, our authority, stated that in that particular cases, the tokens were securities. By doing this, CONSOB applied the definition of prodotto finanziario, of security, that we have, which is very similarly to the US, to the USA, is a quite wide and I would say vague definition, because the definition of prodotto finanziario in Italy is, contains all the financial instruments, which as we know are the notes, the stocks, and the bonds, etc., which are a numerus clausus. So we have certainty of what the financial instrument is. And any other investment of financial nature, which is something very similar to the definition of security in the US Securities Act. Then we had some case law of the authority which defines what is an investment of financial nature, which must be an investment with investment of capital, with an expectation of profit of the investors, and with a risk thereto related. As you can understand, proving that the expectation of one investor or of a multitude of investors to have a profit is quite difficult. So we will see what happens, what will happen of these decisions. So this is the state of the art in Italy regarding this particular field. I can also add that these decisions confirmed my impression of the approach of the Italian authority regarding this new field. Because more than 1 year ago, 1.5 years ago, I was, I think, the first lawyer to have a discussion with the authority. There were, I think, 16 officers of various divisions of the authority. They were very interested and they were very worried, I would say. It was, I think, the week after the guidelines of ESMA. You remember that it was in November, I think, October or November 2017. So also in that case, I was there because I had a client who wanted to launch the first ICO in Italy, and the client wanted to be compliant with Italian regulation, with Italian law. So we decided to go to the authority. And also in that case, I had really the impression that the authority was looking at this particular field with an open mind, but at the same time worried about the retail investors investing in this field. And that particular case, that was an ICO with really utility tokens. So the tokens there were really issued in order for the investors to acquire services of the platform. There was an insurtech project. But in any case, CONSOB said that the officer said that also at that time, the fact that it is an utility token for us does not mean that we don't consider it as a security, because the fact that one investor buys the token and has the possibility to trade that token on an exchange, this could be for us a sign that this is a security. So there is a lot of uncertainty at the moment, and now I close my speech with this, and this means that we really need to have a regulation in this respect. As I said, my opinion is that we should have a regulation on a European Union level, because I don't think it is a good thing that in every state, each state of the European Union makes its own regulation, because we don't go anywhere in this way. So this is my, just a little thing that we try to regulate also the ICOs in a law which will be must be approved within the end of December in Italy. And the proposal was to permit to launch ICOs through the equity crowdfunding portals. This proposal was not approved when it was deleted, and I think it is also right, because I think that this particular field needs an ad hoc regulation, which is different for crowdfunding because they are similar in some aspects, but very different in other aspects, things. So thank you very much.
Yes, thank you, Giovanni. So, and Sylvie, maybe because France is in fact about at least to adopt a legal framework to address.
Yes, as Giovanni was saying, basically all the European countries are facing the same problem. Lawyers don't like, empty legislation or absent legislation. They always need a lot of paperwork to look at and references and definitions. And that's the reason why France launched, and more specifically the Direction Générale du Trésor, launched in March 2017 a public consultation in order to determine whether or not for France to remain competitive on this new market, there was a need to regulate blockchain technology. At the time, Guy Canivet, who was a judge at the French Court de Cassation, was actually very good in summarizing the issue. He said, there are two opposing logics. The need for technological innovation urges not to hinder the development of blockchain technology, but implementing regulatory hurdles. But the protection of private and public interests could be compromised by this new way of carrying out financial transactions. So on the one hand, you don't want to hinder technology, and on the other hand, you want to protect the public at large. That's the reason why, in the first instance, the French legislator was particularly cautious by just adopting a definition of what blockchain is supposed to be from a legal point of view and giving it a more French approach that the distributed ledger technology that they know in the UK or in the US. So a definition to start off with was adopted in two pieces of regulatory statutory instruments. The first one was in an ordinance in April 2016 and the second one in the famous Loi Sapin II. And blockchain was defined as shared electronic recording device which enables the authentication of transactions. Dispositif d'enregistrement électronique partagé. This was only the first step. Then an ordinance in December 2017 was adopted, which officially recognized the validity of share transfers via blockchain technology. Through that legislation, it was possible to start contemplating a real market for the transfer of shares via this technology. It was intended for a decree to be introduced after the adoption of this ordinance. The ordinance came into force in July 2018, but unfortunately, as in most cases in France, we're still waiting for the decree to actually specify more precisely how shares could be transferred via blockchain in a similar manner as they're currently transferred from securities accounts to other securities accounts. It was anticipated for the decree to be published in the autumn, but it's not been published yet, and it's now expected in the first quarter of 2019. Meanwhile, the AMF was also conducting its own public consultation, which was launched, and the name of this consultation was called Unicorn. The Unicorn program was intended to determine what needed to be done in terms of ICO regulations. There were three possible ways of thinking about that: the adoption of best practice guidelines, the extension of the current IPO rules to cover the issuance of ICOs, or the adoption of new and specific rules for ICOs. The findings of the AMF consultation were published in February 2018. 1/3 of the participants in the consultation preferred option one, which was the adoption of best practice guidelines. The idea being that it would be more flexible than proper legislation. But some other consulted parties indicated that it was fundamental to have an information document detailing at least the ICO project and its evolution, the rights attached to the tokens issued, and the accounting treatment of funds raised in the context of the ICO. And it's on the basis of this particular AMF consultation that the French legislature started to move into action. And this gave rise to the drafting of the loi Pacte, la loi Plan d'action pour la croissance et la transformation des entreprises, which was passed through the Assemblée nationale on the 9th of October 2018 and introduces three articles which are key in relation to ICOs in the French Code monétaire et financier. I will read you in French the definition which is proposed because the loi Pacte has not yet been read by the Senate, so it's not been adopted yet. So in French, the text which would be introduced in Article 552-2 reads « Constitue un jeton, tout bien incorporel représentant sous forme numérique un ou plusieurs droits pouvant être émis, inscrits, conservés ou transférés au moyen d'un dispositif d'enregistrement électronique partagé permettant d'identifier directement ou indirectement le propriétaire du dit bien. » And then the loi Pacte goes on to say that une offre au public de jetons consiste à proposer au public, sous quelque forme que ce soit, de souscrire à ces jetons. Préalablement à toute offre au public de jetons, les émetteurs peuvent, et j'insiste sur le mot peuvent, solliciter un visa de l'autorité des marchés financiers. So basically what it says is that the legislature has listened to the AMF consultation. They've come to the conclusion that there was a need for a definition of a token at a legislative level, but that when it came to the actual individual issuing mechanisms, then it would be up to the issuer whether or not they wanted to reassure their potential subscribers by going to the AMF or not. The visa of the AMF at this stage is not compulsory, but is only contemplated on a voluntary basis. The Conseil d'État in France criticized the project, indicating that the regime of token is not imposed by the European Union and not by any other international treaty, and that therefore it wasn't necessary to introduce a facultative mechanism. But at the end of the day, it didn't object, the Conseil d'État didn't object more specifically on the wording of the loi Pacte, which implicitly means that it didn't disapprove the text. On the tax level as well, the issue of how the capital gains realized on the transfer of the ICOs was also contemplated by Bercy. And an amendment was proposed to the 2019 Finance Bill in order to set up a legal framework, or more specifically a tax framework, in relation to the taxation of gains made occasionally by private individuals in the course of the transfer of crypto assets. And the solution that was proposed was to submit such gains to the 30% flat tax and to create a declaration obligation for every person who has a crypto assets account. So again, this is a way forward in setting out the framework in which the transfer of cryptocurrencies and crypto assets may occur from a fiscal point of view. More recently, only 6 days ago actually, l'autorité des normes comptables, which is the accounting norm authority, has issued a publication where it discloses how the ICOs should be treated from an accounting perspective. And only 2 days ago, the AMF announced that it had approved the application of the Napoleon Crypto Fund, which was launched on the basis that it would be the first 100% cryptocurrency asset management fund aimed at professional investors. So things are moving extremely fast, both at the level of the legislator in France and at the level of the AMF. In the absence of any regulations, you will probably have heard quite recently in November that the tobacco retailers were planning to team up with a specific company in order to be in a position to offer their customers to purchase bitcoins directly from the tobacco shops. The AMF and the ACPR and the Banque de France got a little bit worried about this and issued a common declaration to warn the public and insisted in relation to the risk associated with the type of investments. Their thinking was those who buy tobacco are not necessarily the most informed investors and therefore should be warned of the potential dangers of bitcoins in this particular case. But you can see that both our legislature and the various regulatory authorities in France that are concerned with what is happening on this market are being very careful not to hinder the development of the market, but also to make sure that the public at large is protected.
Mr. Shriki, indeed you carried out successfully an ICO, and I think raised a 50 million token representing about 20 million euros.
Yeah, so I will share about this experience. So hello, my name is Vidal Shriki. Well, I'm in the space since a few years now. I've been advising 5 ICOs in France and abroad, and I've launched recently a BTU protocol that has conducted a token sale. We never spoke about ICO, I will explain later. We conducted our token sale fully in France, and so I'm sorry, I'm not a lawyer, but I will try to to give a testimony of how things were conducted here in France and what were the options that we could have. So first of all, the first question for a startup in this space is to know where to be incorporated. So there's a long debate. There's a lot of Twitter streams about this stuff. Since the topic is about conducting a token sale in Europe, so we have many choices. We can go to Switzerland, for instance, where setting up a foundation is easier, and sometimes a foundation is the best structure for this kind of topic, because the main goal of our kind of company is to build and to add value to the token that we have created. So foundation is a good structure. So we can go to Gibraltar. Gibraltar is very friendly, it's very tax friendly. We can go to Malta, that welcomes. But in our case, we still decided to conduct and to incorporate our operation in France. Because we saw that regulators became more friendly, and so indeed we were part of the unicorn program that was mentioned earlier. So we started in December discussing with the AMF, and it was very interesting because at this time there was no regulation. So even the AMF said, okay, this is. When in the discussion, they say, this is our opinion. But we say, okay, we don't want opinion. We want something. You say, okay, but whatever we say, you can do it or not do it. If you don't do it, okay, but maybe in 2 years from now, we will have laws and you will have to comply. But for now, we just can give opinion. And what's very interesting for me that the first focus on the AMF was about KYC and AML. So, and obviously we could have avoided to do it because there is no strict law about it. But of course, we followed the suggestions and we conducted bank class KYC. So we used the same subcontractor as the banks to onboard our buyers, and I say buyers and not investor. That's very important. That's one of the output of our conversation with the AMF, is not to mislead not to mislead the people and the company participating to our token sale. So that is also why we decided not to speak about ICO, because ICO is about coin, initial coin offering. And we did not invent a coin. In our case, it's a token that is used in booking systems as to guarantee the bookings. So it's a kind of stake, and you don't pay with our token. So you make the reservation with the token, so you give the guarantee, but you're not paying with it. So it's very misleading to call this an ICO because it's not a coin and it's not used for payments. And also, people participating to our token sale, they are not investors because we are selling them access to a service. So it's very important to call them buyers because they are buyers. Of course, I will speak it later. Some buyers have the intention of the investors, but it's similar to art, or even it's similar to I can buy a car, I can buy a diamond, I can buy a car, and knowing that this car will be a collection car and will be worth later, but I'm still a buyer, even if my intent is to be an investor. So it's very important not to mislead the people, and that was the key output of our discussion with AMF, and also we realized that one of the other one other concerns of the AMF was about not targeting small buyers, but that are not accredited investor, but not in the legal definition, just in the not people not used to invest. So that is why even we targeted mostly the enterprise. So more than half of our revenue, and I'm not saying the raised amount, it's a revenue. Most of our revenue came from enterprise willing to participate. And that raises another difficulty in France, is that it's hard to, we didn't have at this moment the ANC, the accounting rules that came, and it's very interesting is that the ANC rules, it's not really rules, they give principle, and the principle makes the distinction between what is the intent. If the intent of the enterprise is to invest, the accounting is specific, and if the intention is to really use the token, it's another set of rules. So it's very interesting that it's admitted that both exist, and even utility token can be accounted as an investment. That's very confusing if you didn't spend hours in this kind of topic, but that's the simple reality. And in our case, just to finish, I know time is long, and I can spend hours and I can even write a book about this. We still conducted our token sale with existing regulation. So the legal definition of our token was a real service. So VAT was applied, and so it was similar to any company buying any software license, any AWS service that you pay by use. So they buy a credit of our system and they paid VAT. So we conducted everything in the existing rules, although new rules can come and we could have done it differently, but we had to operate in the world that we came. So the conclusion of my testimony is that it's still possible to conduct elegantly a token sale in France, and we are an example of it.
Lisa, what about Germany? How Germany approaches?
Well, it was actually very interesting to hear. That's what I understand now for the first time, that Italy goes close to the US, because that's what we are always trying to prevent. The public discussion is very much focusing on the US law and the so-called Howey test, which seems to be very similar, which looks at the intention of the investor to make profits from third-party efforts. That is a concept that is in Germany unknown, and it's rather, well, we are looking first of all at it from the European angle. So we're asking, is it a security token according to the MiFID securities definition, or is it not? And for the non-security part, we in Germany have a special thing called unit of account, which is also part of the German financial instruments, but which is not recognized on the European level, and that actually causes a lot of frictions because this kind of financial instrument does not require a prospectus or a license by the initial issuer of the token or coin, but any kind of service built up involving this unit of account, and typically any kind of cryptocurrency is caught by that, will require either a financial servicer license or even a banking license. That is why the German market is basically closed for all of these services, and everybody else is using it. But it's interesting to hear that Italy actually goes the opposite direction, because what we're trying to achieve is an alignment on the European level. And I'm just coming over from a workshop of the European Commission, which is not far from here, where we are discussing regulatory priorities. And that is one of our first goals, to get one token classification across whole Europe, to create one single market in Europe. Because if we splinter in 26 countries with all different token classification, the European market will never catch up to the US or Asian market. So we really need to ensure we have one token classification. And it's great that so many, especially of the smaller countries like Gibraltar, Malta, Liechtenstein, took a step forward and came up with proposals, but actually that simply adds to the splintering. Now you need, for a token issuance in Gibraltar, you need to appoint a registered agent or sponsor, they call it. And it doesn't make any sense. So that would be great. And on the European level, we only have the distinction between securities and non-securities yet, but I understand that ESMA is already considering that they might add another financial instrument to actually catch more of the tokens out there. Because the most popular ones are typically virtual or cryptocurrencies, which are currently only called on the EU level from the AMLD, the fifth anti-money laundering directive, which had been amended during this year. So from January 2020 on, it must be transformed in national laws, and from then on, especially the fiat crypto exchanges will need to do full KYC on their customers, the same with wallet providers. But that's it so far. So I guess we need to move more from the national level up to the European level.